The atmosphere in the congressional hearing room resembled a pressurized vessel on the brink of explosion. Seated at the witness spot, Governor Greg Abbott exuded the calm assurance of a leader seasoned in Texas political battles, someone convinced he'd encountered every imaginable challenge. His wheelchair sat purposefully in the middle, as cameras recorded his every gesture. He leaned into the microphone with the ease of a veteran public official who'd appeared before Congress more often than most could count. His goal that day was to advocate for his latest lawmaking idea, the Community Protection Act, which he'd pitched to Texas residents as the solution to their increasing worries about security. His initial statements came across smooth and refined, packed with the typical tough-on-crime messages that frequently appealed to his backers. "We're just providing police with the resources required to protect our neighborhoods," he declared, his tone blending standard political command with Texas bravado. A couple of chairs away, Representative Jasmine Crockett paid attention with the keen alertness of an experienced lawyer spotting each flaw in the other side's case. The Dallas Congresswoman, aged 42, had built her standing by refusing to accept unchecked political narratives and by preparing meticulously. As other panelists nodded courteously during Abbott's speech, checking devices or whispering to assistants, Crockett stayed completely motionless. Intentionally, her pen glided over her notebook, not merely noting thoughts, but building an argument. Over the previous 72 hours, she'd followed her routine for big sessions, scrutinizing each part of the suggested legislation, talking to experts on civil rights, measuring it against constitutional norms, and gathering actual instances of how comparable policies had functioned elsewhere. Governor Abbott had just wrapped up describing a Texas dealing with escalating offenses, strained law enforcement, and anxious communities. His fix appeared simple: expand police powers, establish fresh types of banned actions, and supply prosecutors with extra options. At first glance, it came off as sensible, wrapped in such direct terms that resistance seemed illogical. Yet Crockett had delved deeper. She'd scrutinized the phrasing hidden in Parts 7 to 12, clauses so ambiguous they might label a disapproving online message as illegal activity, transform a nonviolent rally into a serious crime, and permit officers to break up events they viewed as possibly troublesome prior to any start. The panel leader checked the agenda and declared the instant everyone expected. The chair acknowledges Representative Crockett from Texas for 5 minutes of inquiries. Right away, the mood changed. Journalists in the audience sat taller. Film teams refined their angles, and aides at the rear halted their chats. Those aware of Crockett's ascent recognized that her 5 minutes seldom stuck to the limit, and it nearly always played out differently than the witness expected. Prior to diving into the following events, be sure to tap the subscribe option and drop a comment about your viewing location. You're set to witness a straightforward demonstration of dismantling a political stance piece by piece, and you won't want to skip anything. Maintaining calm poise, Crockett positioned her microphone, locking gazes with Abbott before uttering her opening phrase. "Thank you, Mr. Chairman," she started, her tone steady and balanced. "Governor Abbott, I'm grateful for your presence at this panel to talk about your Community Protection Act. Prior to exploring the details, I need to confirm I grasp your primary assertion. You're claiming this legislation is essential for Texan security. Is that accurate?" Abbott affirmed with a nod, appearing certain. "That's right, Congresswoman. Protecting the public ranks as my top concern, and this law equips law enforcement with the power and means to defend our areas." Crockett nodded, as if evaluating his response. "And in your entire statement, you've emphasized that this focuses on lowering offenses, shielding households, and aiding officers. All aims, I think all present concur, hold significance, correct?" Abbott's grin broadened. "I'm pleased we share that view, Representative." It was an entry point Crockett had prompted. "Shared agreement serves as a solid foundation," she responded. Her manner stayed courteous, yet with a distinct adjustment that drew heightened focus from those present. "So, let's examine the bill's true actions. Governor, not the media summary or the scripted lines, but the real text you're urging Congress to endorse and finance." She raised a hefty version of the legislation flagged with color markers and personal annotations. "Section 7 in your Community Protection Act establishes a fresh violation termed organized disruption. Could you clarify for this panel what counts as organized disruption by your standards?" Abbott adjusted a bit, keeping his composed demeanor. That part deals with cases where assemblies deliberately upset communal peace, obstruct streets, or interfere with legal commerce. It's fundamental safety strategy. Crockett flipped to a marked section. Allow me to recite the precise phrasing, Governor, since the audience merits the particulars. She voiced it clearly. Organized disruption will be described as any assembly of 3 or more individuals that generates or could generate hindrance to regular functions, vehicle movement, commercial activities, or communal utilities. She glanced upward. Based on this wording, couldn't university students rallying against fee hikes on a communal path face organized disruption charges? Might guardians positioned near a school council session to voice issues get detained? Could employees striking for better pay get charged? Abbott's grin grew strained. Such scenarios are speculative. They're far from speculative, Governor, Crockett replied steadily. These represent everyday safeguarded First Amendment practices occurring daily in Texas and across the country, and your legislation deems them unlawful. Whispers filled the space. Multiple panelists began scanning their own bill copies. Abbott attempted to steer back. Congresswoman, I think you're misconstruing the purpose. I'm not construing a thing, Crockett stated, her tone stronger. I'm citing your document, and I haven't concluded. She moved to the following marker. Section 9 permits officers to scatter any assembly they think holds disruptive possibilities before any actual interference happens. That's advanced suppression. Governor, the Supreme Court has ruled for years that authorities can't limit expression due to anticipated events. Abbott moved closer. Representative, with deference. Public protection occasionally demands public protection doesn't supersede the Constitution, Crockett countered right away. And that's precisely what this legislation seeks to accomplish. She pressed on without letting Abbott interject. Section 11 imposes penalties for employing online platforms or digital messaging to arrange events that could result in interference. She then stared directly at the lens. Governor, are you aware of the implications? You've rendered it illegal for people to utilize Facebook, Twitter, or simple texts to set up a demonstration. You've converted essential instruments of civic involvement into actions viewed as unlawful. Abbott's expression started revealing annoyance. Those clauses feature protections. Where? Crockett inquired. Point out the protections, Governor. I've gone through this legislation 3 full times, and I've consulted constitutional experts from the University of Texas, SMU, and Baylor. Do you know their consensus? They indicated the legislation wouldn't hold up to its initial legal test. They noted it directly erodes the First Amendment, and they observed it's crafted to accomplish just that, stifle opposition and punish rallies. The whispers in the space intensified. Abbott changed approaches, his manner turning a touch patronizing. Representative Crockett, I realize that as a congressional newcomer, these matters could appear. Governor Abbott, Crockett interrupted, her tone resolute and exact. I'll halt you right there. Prior to entering Congress, I worked 15 years as a civil rights lawyer. I defended demonstrators detained for using First Amendment freedoms. I've contested unconstitutional statutes like this in state and national courts. So, don't imply I lack comprehension of what I'm assessing. The space grew quiet. Abbott's prior assurance diminished, and even certain Republican panelists seemed uncomfortable with the dialogue. Crockett proceeded, aware she'd altered the exchange. Let's consider the real results of statutes like yours, Governor. We don't require guesses. We possess definite cases. She displayed another bundle of papers. Following the 2020 George Floyd demonstrations, no fewer than 17 states enacted comparable statutes. Here's the outcome. In Oklahoma, senior campaigners got detained for assembling outside the state capitol to oppose schooling reductions. In Florida, ecology supporters faced serious charges for arranging a shore cleanup that featured climate messaging banners. In Iowa, advocates for disability rights got prosecuted for impeding entry to a lawmaker's workspace amid a medical care rally. With every instance, Abbott appeared more strained. Crockett wasn't presenting ideas. She was illustrating exactly how equivalent statutes have been used to mute ordinary citizens. But here's my larger worry, she stated, her manner intensifying. Your legislation extends beyond those state versions. Section 12 establishes civil accountability for anybody offering tangible aid to actions resulting in detentions under this act. Are you grasping the meaning? If a religious group supplies hydration to demonstrators on a warm afternoon, they might face lawsuits. If a nearby company permits activists restroom access, they could encounter fines. If a lawyer gives complimentary advice to an individual detained under this statute, they might be accountable. She inclined a bit ahead. Governor, you're not merely outlawing demonstrations. You're attempting to block groups from aiding each other in utilizing constitutional freedoms. That's not safeguarding the public. That's tyranny. The statement hung in the air. Reporters keyed in swiftly. Flashes went off. Abbott's look transitioned from assured to aggravated. Representative Crockett, he responded stiffly. That depiction is totally unjust. Is it? She questioned. Permit me to pose it straight. Under your Community Protection Act, might the civil rights participants who marched from Selma to Montgomery in 1965 have faced detention? Abbott hesitated, evidently conscious of the consequences. The era's background differs entirely. Respond to the inquiry. Might they have faced detention under your legislation? Yes or no? The details would hinge on yes or no, Governor. Crockett urged. Would the Selma participants, individuals seeking suffrage, be labeled offenders under your law? Abbott's mouth stiffened. The goal of that event and aim of this legislation are entirely. That's not my question, Crockett answered. Per Section 7, more than 3 individuals were hindering vehicle movement. Per Section 9, they might have been scattered for possible interference. Per Section 12, the religious institutions and relatives who assisted them could have faced sanctions. Your legislation would have rendered the civil rights effort unlawful. Governor, the space burst into chaos. Certain Republicans demanded calm. Democrats cheered. Journalists yelled inquiries. Abbott remained at the witness position, his prepared remarks crumbling. Crockett went on, raising her small constitution, a habit she frequently employed in intense sessions. Governor Abbott, she declared, her tone steadfast, the First Amendment doesn't state Congress shall enact no law limiting free expression except when an official labels that expression interfering. It doesn't state the assembly right stays whole unless a governor chooses differently. It declares these freedoms shall not be infringed. Period. She gestured toward the legislation. This law infringes those freedoms multiple times. And you requested this panel to regard it as standard public security, presuming nobody would inspect it thoroughly. But I examined it. My team examined it. Legal authorities examined it. And we all arrived at identical findings. This legislation is hazardous, against the Constitution, and unfit for a liberated community. Abbott tried to reclaim direction. Representative, if you permit me to clarify the background. The background, Crockett answered, is that you're seeking national funds for a regional statute that outlaws constitutional freedoms, and this panel would neglect its duty if it provided you any funding for that goal. She faced the leader. Mr. Chairman, I propose we promptly postpone any deliberation of national backing for Texas's Community Protection Act until a thorough constitutional assessment by the Congressional Research Service. Multiple Democrats rapidly endorsed. The leader, caught off guard, requested quiet and indicated the proposal would be evaluated while others continued their inquiries. The effect was evident. Abbott's effort to portray the legislation as logical safety measures had been taken apart. Segments of Crockett's inquiries circulated on social platforms. In under an hour, Crockett dismantles Abbott trended across the country. Law specialists contributed. Ex-Attorney General Eric Holder posted, Representative Crockett's inquiries to Governor Abbott exemplified constitutional insight and strong supervision. The ACLU released a declaration commending her evaluation. Even traditional law experts who first backed the legislation started withdrawing. One informed Fox News he held worries about constitutional problems he hadn't entirely weighed. By nightfall, Abbott's team issued a protective announcement asserting Crockett misconstrued the legislation, but the political harm was complete. Texas lawmakers set to approve the legislation hesitated. Countrywide Republicans eyeing similar statutes retreated. 3 days on, the Congressional Research Service published an initial document identifying several parts of the legislation as posing major First Amendment issues. 2 weeks afterward, amid mounting stress, Abbott announced he was reassessing sections of the law, broadly interpreted as recognition that the legislation lacked feasibility. For Jasmine Crockett, the session marked another pivotal point in her countrywide recognition. But during a community gathering, she maintained her comments centered. "I didn't aim at Governor Abbott individually," she stated. "I opposed a legislation that would have converted constitutional freedoms into illegal actions. My role involves scrutinizing laws closely, grasping their practical effects, and voicing concerns when anything endangers core liberties." An elderly woman in the crowd, detained amid a calm rally against contamination close to her grandkids' school, rose with emotion in her eyes. "Thank you for scrutinizing those laws so meticulously," she expressed. "Thank you for grasping their implications for folks like me." The instance, captured on a device and extensively circulated, illustrated why Crockett's inquiries struck a chord. She wasn't pursuing notoriety or aiming for a popular segment. She was safeguarding the freedoms that enable Americans to express views, gather, and demand accountability from their officials. If this dissection of how Representative Jasmine Crockett opposed Governor Abbott's unconstitutional law proved useful, press the like option and subscribe for additional insightful reviews of crucial instances in U.S. politics. Leave a comment with the topics you'd want Crockett to tackle next, and distribute this video to anybody focused on safeguarding constitutional freedoms. Your backing assists us in ongoing coverage of vital narratives about preserving democracy.